speaker is Elizabeth Outler, and she is head of public services and also tax law librarian for the University of Florida Levin College of Law's Lawton Childs Legal Information Center. Her primary research interest is access to government information, focusing particularly on the Freedom of Information Act and other government information laws such as the Federal Depository Library Program and the E-Government Act of 2002. She received her JD from the University of Florida in 2005 and is a member of the Florida Bar. I am really pleased to have Elizabeth here to talk to us on maintaining author rights to your own intellectual property. Such an important topic. Thank you, Elizabeth.
Okay, so as Isabel said, my name's Elizabeth, and you can forget my name after today, because I'm not really an expert on open access issues in scholarly publishing the way that a lot of the librarians that are in this room are, because in the law school, in legal publishing, we don't deal with quite the same types of issues in quite the same publishing world. And so I do have a law degree, and but all librarians think a great deal about copyright. And the librarians that are your liaison in your library that you work with normally are the resources that you should go to for these issues. So I'm here to be the speaker, but your liaisons in the Smathers libraries are really your primary resource for this information. So my topics today are going to be pretty basic. I have 45 minutes allotted to me, and I hope that's going to be used a lot by people's questions if you have any. I don't know that I will speak for 45 minutes, but we'll see. So I'm going to start with some basics of author rights, and by author rights we really mean copyright, because I'm going to assume that we are not all starting from the same place in our understanding of that. So I'm going to go really basic with the copyright information. Then I'll talk about copyright in the context of publishing agreements and the types of restrictions that are placed on author rights in those agreements and why that's relevant to this conversation that we're having today about open access publishing. And then we will talk about some alternatives to the way things have been done in the past that are available to authors and are really necessary to consider when we're talking about furthering open access initiatives, whether you're publishing in open access journals or putting your work into the institutional repository. And those are the author's addendum and the Creative Commons license. So, we'll start with the background, which is the fundamentals, and getting into why this topic is important information to supplement the rest of the information that you've been hearing today. So, copyright basics. Copyright is automatic. Authors are automatically entitled to certain rights having to do with their work when it's created. As soon as you write something or paint something or take a picture, all of the rights associated with copyright sort of magically adhere to that thing. You don't have to do anything to get copyright. You can place a copyright symbol on your work to make sure everybody knows that it has copyrights attached to it, but that's not required. It used to be. It used to be required to register with the government. It's not necessary to do that. You get some benefits from placing a copyright symbol on your work, but it's not necessary to actually have that for getting copyright. So what is a copyright? Copyright is actually a bundle of rights. Includes a lot of different things. The ones that are really relevant to our conversation today are copying, that's why we call it a copyright, publishing, so distribution, which, by the way, these two together are the ones that are most implicated in placing stuff on a website. So when you place stuff on the web, you are distributing, and everybody who looks at it is making a copy, because you have to make a copy to put it in your web browser to look at it. So copying and distributing are involved when we place stuff on the web. There's also preparing derivatives. Derivative is the word that's used in the copyright law, and it covers a lot of ground. It basically means that if you're taking a creative expression that you've already made and developing it into something else. So if I make a translation of a book that I have written and I want to publish that, that's a derivative, or an article. A lot of times in law school classes on copyright, we use the example of making a book into a movie, not a movie into a book, although that would work too. If you're changing the form of the expression, but essentially retaining the same expression that's already got copyright, that's a derivative. Performing or publicly displaying a work, which may not be relevant for some of the things that we're talking about today, or licensing other people to do any of the things that you have that you yourself exclusively have copyright to do. You can give away or sell the rights to other people to do that while retaining all of the rights yourself. Or you can give them away forever. So you might be saying to yourself, this is fantastic information, but why is that relevant to me? And it's because it's relevant to this conversation because, as some people have mentioned already, what very often happens when people publish, scholars, professors, students, publish their work, they're giving it away. They are giving all of it away. And it depends really on the agreement that you have. So traditional publishing agreements required authors to transfer their copyright. Many publishers still use this as their default position. It may not be that you would establish that you would transfer your every single right that you have, but very often that's the case. And they do this to maximize their own ability to profit, to make it easier for themselves to keep track of what they own. If everybody is giving them all the copyright, then they don't have to remember that for this author, I said that they could do certain things, and for this author, I said that they could do certain things. And so when I have to go back and redo my website, that I know that I can make certain uses of certain articles, and so they don't have to renegotiate every time. It makes it very easy for them to do business if they just take everything, and they know that it's always the same, and they have certain freedom to make different decisions. Now, it's not necessary, strictly speaking, but it's what they've done. And under this model, traditionally, authors do retain some rights, and you can read your author agreements, and this is sort of going to be the refrain of what I'm going to be talking about today, and that is read your author agreements. Keep a copy and remember what they say. So usually there's exceptions, wherein the publisher has agreed to allow you to have some rights, but like the ones exampled here. But there are some contracts where you just turn over your entire copyright and you don't have any rights. But people don't realize that they've done that. So you could be violating copyright all the time by taking your own paper and distributing it because you think, well, it's your paper. Why can't I share it with people? But you've given away all of your rights to that thing, and so you're just like everybody else. You have to ask for permission to make copies of it, to distribute it, to put it on your course website, those kinds of things. So there are some agreements that don't contain those useful exceptions. So what copyright means, this means that you might have to ask permission, surrendering copyright means, you might have to ask permission from your publisher to reproduce your article in later works, if you want to do further copies of it, to prepare a translation, as we mentioned earlier, to distribute it in other forms, which would include distributing copies of your article to colleagues. As one of the recipients of the publishing fund was mentioning earlier, once the article's published, if you want to tell people about it, are you allowed to send a copy of your article to your mom, to your colleagues in China? What if, as another recipient was mentioning, what if they don't have access to the database? What if their library doesn't pay for that? How are they going to get a copy of it? Are you allowed to make copies and send it to people? We all know, I guess teachers know anyway, about the types of things that you have to do to complete your articles, or other people's articles in course packs or on course websites, and in electronic reserves. But there's also your personal website. Are you allowed to promote your works there? That's a question that you need to keep track of. And then of course there's the institutional repository here at UF. And there's open access repositories for various disciplines that you may want to share your work and make it more available. You may not have the right to do that. Depends on your publishing agreement. This is changing for the better. We make it sound like it's terrible. That there is a lot of work, as Dr. McClellan was saying earlier. You know, this has legs. It's a big movement. The government stepped in with the NIH funding requirements, so many publishers are quite used to authors saying, but I have to make this open access, I have to make it available. So there are publishing agreements that are sort of containing default language that allow for that type of use, that you could deposit into an institutional repository or disciplinary repository. And they are also getting more and more used to authors coming back and saying that they want to renegotiate the terms of the agreement that they've been offered. So it's getting better, but it still means that we need to pay close attention, because it's still very varied across publishing. It's by no means monolithic. So there's two ways to think about what you could do. One is the more common, which is reserving specific rights to yourself in your agreements, making sure that you know ahead of time what you want to ask for, and being able to read the language that's offered to you and know whether that's giving you what you need. And then, and sort of thinking about what those rights are. We've talked about some, or I have talked about some so far. Making copies, uploading a copy to the institutional repository, making derivatives in the future that you can imagine that you would want to retain the right to do. Another approach that might be a little bit more revolutionary is just saying, no, I'm not going to give you my copyright and then reserve certain rights for myself. I'm keeping my copyright and I'm granting some rights to you. And that's a license, usually is what we call that. Dean Russell mentioned at the beginning that one of those things that you might do is just license the right of first publication. That's all they really need, because then they can continue to have it in their journal forever, because that's the first publication. They'll make money off of it, and then after, whether it's after a certain period of time that you're able to republish in other forms, put into the institutional repository, all of the other things that you might want to do with your work. It accomplishes sort of both goals. And so a lot of times I think authors get to this point and they say, okay, well then how do I do that? I think what it means is that it's going to require negotiation. It's going to require being willing to take the time to read the agreement, to talk to the publisher about it, to challenge it a little bit if necessary, and to take responsibility for your own rights to your work. So read the agreements carefully before you sign them. Think about what you're actually going to want to realistically do. And if you believe in supporting open access on our campus, then the moment when you are first publishing your work is when you must act to reserve some rights to make your work available. Another strategy, and I wanted to show this, I did not make a slide for this, but I wanted to demonstrate this. I've got a resources slide at the end of the presentation that has links to resources, and this is one of them. Another strategy is to shop around. So there's been mention of the Directory of Open Access Journals. So if you use open access publishing, they're not going to take your copyright. So, and they will be licensing and making stuff available by open access. That's one solution. The other is to shop around for publishing agreements or publishers that have agreements that allow you to do certain things. And this is the Sherpa Romeo website. This is, I believe, I don't know a whole lot about this project, so there's other experts in the room that can talk to you about it. But it's a British not-for-profit open access website where they basically collect publisher agreements and help you compare them so that you can sort of know ahead of time which publishers are friendly for more open access or more negotiability for rights. So that's what that is. Okay, so moving on. So the negotiation part, this is where the author's addendum comes in, which is, I guess, sort of a legal word. I don't know if you haven't heard of the author's addendum before, if it'll make sense to you what we're talking about. So what is that? The addendum is something that you attach to the publishing agreement that they send to you. So you've sent your article in for review, and they've said, we love it, we're going to publish it. You have to sign the publishing agreement. So you read it, you sign it, you grab yourself an author's addendum, which is sort of like, it's basically an additional page with more contract language on it that you're adding, addenduming, to your contract. I like to make up words. And what it does, it makes it easier for you. You won't have to, these are ready-made documents that are being provided by organizations, by universities, by people that are promoting open access publishing that makes it easy for you to do that. It reserves specific rights to the author. It supersedes the language of the contract that you've signed. The fundamentals of contract law allow this, that when you add language to the agreement and send it back, it's a form of negotiation. And when the publisher accepts it, doesn't reject it, doesn't send it back to you, doesn't say, no, we have no deal, never mind, they've accepted the language that you provided. So when you send a contract back with the addendum and they don't say no, you got a new contract with those additional terms. So some people think that this is maybe a little sneaky, but they should be reading their contracts too, just like you should. And you can expect to see that the language within the addendum actually makes this quite explicit, that once the agreement is accepted without objection, it becomes part of the contract. So there's many sources for addendum language and forms. One is SPARC, which stands for Scholarly Publishing and Academic Resources Coalition, which is part of the Association of Research Libraries. SPARC, I'm not going to show you the SPARC website now. I think you should go and take a look at it on your own. But I did include it in the list of resources at the end of my presentation, which should be available in the institutional repository afterwards. But we also have an open access website where I believe all of our slides will be available, as well as probably the video that's being taken right now. So there's SPARC. There's also an organization called Science Commons, which is part of the Creative Commons organization. And I'll just sort of as an example, there's also many universities that are working towards the type of work that we're doing here today, which is to, they are promoting open access on their campuses by providing standard language for an author's addendum to their faculty. So University of Minnesota is one place where I found they're doing that. It's actually, they're using an addendum that is, I believe, provided by a Big Ten coalition, where they are all working on having common language for that kind of thing, so making it easier. All three of those websites, where you would find the author's addendum and information about it, have a lot of supporting documentation, question and answer pages, a lot of help to help you figure out exactly what language you should use to accomplish what you need to do. These organizations are very active, and they have a lot of information to help you figure it out. Now, I don't know how well this is going to be visible up here, but I thought I would show just an example of what it looks like, and it looks very contracty. And again, I can't tell whether you can see this or not, so I'm just going to read some of it to you. I've underlined some of the key features to demonstrate the kind of basic language that makes the addendum work. So the first thing that's underlined there, underneath the blanks at the top, says that the parties agree that wherever there is any conflict between this addendum and the publication agreement, the provisions of this addendum are paramount and the publication agreement shall be construed accordingly. So what that means is, no matter what the agreement says that the publisher provided you, if the addendum says something different, addendum wins. So maybe your agreement says, publisher gets all the copyright, and your addendum says, yeah, that's great, but I also get to keep some rights for myself. Addendum wins. So you're adding language to the contract that you want to put in there using the addendum. In the big paragraph in the middle, it lists some additional rights that authors might want to retain. So it says, notwithstanding any terms in the publication agreement to the contrary, the parties agree that in addition to any rights under copyright retained by the author in the publication agreement, author retains the right to reproduce, distribute, publicly perform, and publicly display the article in any medium for non-commercial purposes. So you would not be competing with the publisher. That ought to be welcome news to them. The right to prepare derivative works, the right to authorize others to make any non-commercial use of the article, so long as author receives credit, and the journal in which the article has been published is cited as the source of first publication. So again, you're doing them a favor and yourself for reserving to yourself the right to reasonably reuse your own work. And an example is given at the end of that paragraph. Author may make and distribute copies in the course of teaching and research, and may post the article on personal or institutional websites and in other open access digital repositories. So that's a classic author's addendum. Are there any questions about that before we move on to talking about Creative Commons licensing? Yes, Jean.
Do you have to put anything on the original part of the agreement that says, hey, there's an addendum?
I'm not aware of that requirement. I mean, it's when you attach it and make it part of it, it says that it's part of it, so it's all together as one package. Now again, my disclaimer is I'm not a contract law expert, but there is also, like those types of questions, I think the details of the actual nuts and bolts of how you do it are on the organization websites where they provide the forms and educate you about actually executing the agreements. So that's where I would go if I were trying to answer that question under oath or something. Yes?
If you just attach a piece of paper that says, I retain the following rights, and sign it, attach it to as top of the addendum to publication agreement, is that as legally binding as this? It's just this spells out the specific
yeah.
rights.
This is, basically all this is just making it easier for you. So it's providing language so that you don't have to think of it yourself, I guess. I mean, so there's people that have sat down and spent a lot of time trying to figure out what's the best way to do this. That's why they're providing it. But yeah, if you want to rewrite it for your own purposes, or write something that it is more well suited to your individual situation, it should work exactly the same way. Any other questions? Okay. Any disagreements with anything that I've said so far? You're wrong. It's okay. Okay, so lastly, and I've been trying to figure out how to do a smoother transition between an author's addendum and the Creative Commons discussion, but they're almost like bookends. I mean, they're both part of this discussion of author rights and what you do with them in the world of open access publishing. Sorry. So what is Creative Commons? If you don't know what it is, it's weird. When I put that at the top of the slide, I thought, okay, well, there's actually two answers to that question. One is that Creative Commons is an organization. It's a not-for-profit organization founded in 2001 by some people from Duke and Harvard and Stanford. It's funded by donations. And I've quoted here the purpose that they state on their website, and part of the reason I do that is because the language really is important, and it's very plainly stated, and that the purpose of Creative Commons is to make it easier for people to share and build upon the work of others consistent with the rules of copyright. And the important part of that is that Creative Commons is not looking to replace or supplant copyright law. You get to keep your copyright, nothing changes about the way that copyright is enforced. You are simply you're using Creative Commons as a device to share your work, consistent with the rules of copyright, but make it easier for people to do that. So you will still retain your standard copyright, but imagine if I'm a user and I'm trying to be very diligent and careful about not violating people's copyright, if I'm looking at papers that they've posted on their website, how do I know whether I'm allowed to do anything with them? I might assume if you publish it on your personal website that it's freely available, but I probably shouldn't assume that, and so I would need to contact you every time I want permission to make a copy and get an agreement to do that. But if I'm an author and I want to just share my stuff on my website, it's easier for me to have a standard way to do that everyone can recognize when they look at my website and know that they don't have to contact me for permission. My terms of sharing are there, right there, easy for everyone to understand. So that's what Creative Commons is doing. So it's a license for copyrighted works. The articles, the books, the plays, the pictures, the slides are still copyrighted to the author. So a license is another word for a contract. We're still talking about contracts. The contract in a Creative Commons license is what is granting permission to the user for their various uses that they might have for your work, for copying, for sharing within standard limits that are defined by these licenses. And again, it makes it easier for consumers of your work to use it. Sorry, every time we touch the podium, it makes this lovely droning noise. So let's talk about specifics about Creative Commons. There are 4 conditions, starting with attribution. Attribution means acknowledging where the thing came from, who the author is, and sometimes where the source is. Non-commercial is one of the possible conditions, which fairly clear again. It prohibits the reuse of the item for any commercial purpose. No derivative works. So I'm making clear that I am posting it for you to have and read and hold close to your heart, but you may not make any new thing out of my thing. And share alike. And this is the sort of most particularly Creative Commons-y thing that is theirs, is the share alike condition. And it is that, which requires anybody who uses your stuff, that if you place that condition on there, that they have to also share whatever they're doing with your work under the same conditions with other people. So if you're publishing something in open access and you put a Creative Commons as a share alike license on it, and somebody reuses your work, they have to share alike too, and it goes along. So it encourages sharing and makes it easier to do that. So those 4 conditions are the basics of a Creative Commons license. There are actually 6 different licenses. We're going to try to breeze through these. And I will sort of discuss them using my slides as an example. So my slides are magically copyrighted to me after I made my presentation. So let's say after this presentation, I post my slides on the library's Open Access Week website and into the institutional repository, which I will actually do, so it's a really relevant example. And I could choose any of these Creative Commons licenses to place on my slides. The most open one is attribution. There are no other restrictions being placed on them. You can do whatever you want with my slides. You can copy them, you can sell them, you could stand up here, you could go and get people to pay to see you speak and use my slides as long as you put my name on it. Doesn't matter, I don't care. I'm that generous. All I require is that attribution be given to me. Now, attribution and share alike combined together into one license. I can add one requirement to that, which is that you do the same thing. After you steal my presentation and go make money off it, you have to put it up and share it on your website or whatever so that other people can steal from you. And the other thing thinking about too is that you can maybe, and as some of you can probably imagine, this is something that I was doing when I was working on this presentation, is looking at other presentations where people have done stuff on similar topics. Sometimes you do want to steal someone's slide. That's the perfect slide. I want to put it in my presentation. Well, if you have a Creative Commons license on the content that you're making available to people, they know that they're allowed to use it. That's a good thing for a lot of us anyway. So the third one though would not allow that because it says attribution and no derivatives. So which actually thinking about it is kind of strange. So I wouldn't allow you to use just one slide and to take my presentation and tweak it and make it into something else. You have to use my whole presentation if you're going to copy it. You can't piece it up. So I would allow you to steal my whole presentation and go get paid for giving it again, but I wouldn't allow you to take one slide and put it in your presentation. But no matter what you do, when you copy it, you have to put my name on it and say where you got it. Attribution and non-commercial, this is starting to get predictable, so no one can make money off of my work, except for me. You can make derivatives, but you can't charge money, and you must give me credit. And the last two are the triple combinations and the most restrictive, depending on how you look at it. The first of these is what we call attribution, non-commercial, share-alike. This is probably the most common use for a lot of scholarly works, I think. Somebody can disagree with me who's more experienced with this if they like, because I could be unaware. So, attribution, you have to cite the source. Non-commercial, please don't sell it. And share-alike, so that when you are reusing it, you need to also be doing the same thing. Sharing alike and putting the non-commercial restriction on it. So this combination would allow derivatives. The last one would not. So attribution, non-commercial, no derivatives. You can copy and redistribute my article, my slides, my play, my photographs as much as you want. You can't change them and make them into your own thing. You can't make money off of it. You can do whatever you want with it, but just make sure that you cite your source. Okay, so how do you make use of this if you want to? The Creative Commons website is given here. Not going to take the time to take you over there and show you, but they have a great, very simple, very streamlined website with really just the most important information. A lot of supporting documentation, a lot of sort of model examples and questions. All of the information about the individual licenses. It is the place where the actual source licenses are housed, so the actual legalese of the contracts are there. And that's what you're making reference to when you pick one and put that information on your work. So read the information, decide what you want to use for your work. You don't have to tell anyone at Creative Commons that you're doing it. They don't care. I mean, they care. They're glad. And they'll know because when you place a Creative Commons license on your work, you have to link basically back to the text so that people will know the license that you're granting them. So you would use the mark, which we can go back and show you. So those are the marks, those boxes on the left there. And those images are all available at the Creative Commons website. So you would display the mark, display the language that Creative Commons tells you to use, display the link back to the Creative Commons website, and that's it. Now, so the reason why this is important is that it's the other part of thinking about when you publish in an open access journal, what uses do you want to allow when you are giving open access to your work. An open access journal will have its own ideas, most likely, but they're also going to allow you to make your own decisions about it. The same thing is true when you deposit your work into the UF repository. You're going to need to put a Creative Commons license of some kind on there so that you tell your users what you're allowing. They're going to think, obviously, that it's freely available to them when they pull it out of the open access repository at UF. But if you want to allow them to do more with it, you can do that using a Creative Commons license. So no matter how you choose to publish, either in traditional or traditional for-profit journals or in open access journals, sort of the message is you have to think carefully about the rights that you want to retain and the uses that you want to allow of the work after it leaves your hands. And also thinking about, making it freely available to the public, to other scholars, all of the reasons that we've been talking about today for why open access is important. This resources slide is some links to Spark, Science Commons, Sherpa Romeo, which I showed you, and the University of Minnesota's website where they have some good information. And that's just an example. There's a lot of universities that are doing that, including this one. But theirs was particularly helpful to me when I was preparing this presentation, so I thought I would share that. And that's all the information that I have today. Are there any other questions?
I have a question.
Sure.
So I did go to find a Creative Commons license source for a photograph that I used on the website. And it was an attribution, so I did photo credit, linked back. Do you have to use their little logo thing, or can you just use the attribution?
Oh, when you reuse
When
the
I
program?
the container.
If it's attribution only, I don't think that you have to. If it was attribution and share alike, then that would sort of require you to also put a Creative Commons license on it when you're putting it. But if you have the link back to the source, that should take care of it, I don't think. Yeah.
Hi again. In my experience as institutional repository coordinator, which means I do a lot of things at one time, including have this time with you all here today, we have and we use within the institutional repository Creative Commons. It is intended as sort of a translation tool. It's a picture that you look at that gives you some guidelines. You don't have to use Creative Commons, but if you think it will help you express to people who use your research and would like to share your research, do so responsibly. You post it with your chosen graphic, and you hope that they choose to do the right thing, which is what you have asked them to do.
Although, frankly, I think the other thing about this to me is that it's still, if people don't choose to do the right thing and you catch them, you can still sue the crap out of them the way that you could under normal copyright. So you are retaining your traditional copyright rights to enforce the control and distribution and copying of your work. But once you've applied the license, you've given permission for reuse under certain conditions, but you can still enforce the stuff that's outside of those bounds. So when you discover that people are not being responsible users of your work, you can still go crazy the same way that, the record publishers are going after people and all that kind of stuff. And copyright still exists. It's still enforceable under this regime. Yeah.
It was very close.
Yeah, it was a draw, almost.
When we put things on a UF served website, it seems like there's already a copyright statement that's implied or even expressed at the bottom of the pages that say it's copyright belongs to the trustees of the University of Florida and that sort of thing. So then we also have the right to set up a Creative Commons
It
in addition to
depends,
that, or
I think.
separate from that?
This is where we're getting outside of my expertise. I don't know the straight up simple answer to what you're saying. I think it depends, frankly. I think it depends on the content and the way that you're displaying it. I think it depends. So, if it's your work, your scholarship, your teaching materials, I believe it's yours. If it's your website for your job, where you're linking people to resources and describing them and all that kind of stuff, it probably belongs to the university. That's my guess.
Actually, technically, according to the general counsel's office, anything that's done as an employee of the University of Florida, the University of Florida technically has the right to own that, but they don't really exercise that right. They haven't actually enforced it in practice, so that authors do successfully claim their own copyright, but technically and officially, University of Florida could reserve the right to that work.
And librarians as translators, I am one with many words. We try to navigate the middle ground. I am setting an example for you by hosting an open access repository that compiles the work from one institution that might also serve other subject areas, so it might also include things published by people who are not, according to the registrar's office, gators, but in one sense we all are, because we all work together, and that is really the most important thing. Please know that we advise you in our best capacity. General counsel has the final word, because we don't want you to get sued. And if you need to sue somebody because the University of Florida copyrighted something and somebody else is profiting from it, who is not the author or the university in the strictest University of Florida Board of Trustees sense, I hope to think that the general counsel will support you sue them and sue them hard.
Right. And so they should be consulted.
They
too,
should be
right?
consulted all the time, but they're very busy, and so are we.
Right.
So we try to translate for them as we may do so.
I had one question. I was actually at listened to a webinar yesterday that there was the scholarly librarian up at MIT gave a talk about open access initiatives up on their campus, and they had mentioned that the faculty at MIT had sort of adopted, like the faculty, not the librarians, not the administration, anybody else, just the faculty. Adopted a policy of self-archiving in the IR and those kinds of things. And they went so far as to draft their own institutional, like MIT-wide author addendum, I guess similar to what University of Minnesota has done. I haven't gotten a chance to look at that yet. Any idea, and this is not just directed at you, but anybody in the audience, does anybody have any idea if something like that is being thought of here at UF, either among the faculty or in the general counsel's office or anything?
Well, actually, because so many universities now are moving toward open access mandates and policies, we do envision that we're going to have something of that sort in the future, but it will have to be faculty driven. It will have to be based on faculty discussions and debate, but I would imagine that, it's certainly our goal that in the future, in your future, we'll have some kind of statement supporting open access publishing, whether it's just publishing in the IR or also open access publishing in journals as well.
Right, because I would like to encourage, a lot of the faculty in my areas in the chemical sciences generally don't have a lot of options as far as open access journals, but I would like to start encouraging them to look into the possibilities of archiving their work in the IR, but doing so consistent with the copyrights of the journals that they're choosing to publish in, if that's at all possible. So having some sort of university faculty statement on this would be incredibly useful.
I volunteer that tomorrow there is a faculty senate meeting. If you are here and you are a faculty member, you have a senator who may or may not attend that meeting. They have voting privileges, is the way I understand it, faculty senate. I have a lot of words, I apologize. If this is something that you're passionate about and you want to help this move forward in an official capacity, faculty driven, librarians as faculty are a different breed of faculty. We need you to talk with your faculty senator. Officially, that is the way that things happen here. Okay?
And the Dean of Libraries will be making a presentation at the
Yes.
faculty senate.
And hopefully they let me back in this building with my posters again. So there will be at least me and hopefully some of my colleagues to answer any questions you might have.
Okay, well, I don't want to take any more time because there's another speaker to follow me. But there will be certainly time for questions again, although I guess there was one other person. You raised your hand.
Yeah.
Yeah, I was gonna ask how often you made reference to suing the crap out of people and record publishers suing. How often or if ever, do the publication companies go after somebody who may have sent somebody, hypothetically speaking, a PDF of one of their papers to somebody in Czechoslovakia who had no access. I mean,
Well, I would say that you're probably right that under those sort of individualized circumstances that publishers are unlikely to know and unlikely to pursue authors for that sort of thing, although there are recent active continuing lawsuits against universities for misuse of copyrighted materials in electronic reserves. So the other thing is that I think once you distribute something improperly, you then have no longer control over how it's further distributed, and you can be implicated and blamed for those sorts of things. So it's always wise when you're acting on behalf of the university to follow the law. But in terms of how big the risk is, it may not be that big in most of the types of situations that you're describing.